Judge Neomi Rao did not expect a sitting member of Congress to walk into her courtroom and shatter her authority in front of the nation. But that is exactly what happened when Jasmine Crockett stepped up to the bench. What began as a routine hearing exploded into one of the most intense, emotionally charged, and career-defining moments in modern judicial history. In just 30 minutes, power shifted in a way that no one saw coming. And when it did, even the most seasoned legal observers sat frozen in disbelief. If you want to hear the full truth, make sure to hit that subscribe button. The federal courthouse in Washington, D.C. buzzed with quiet intensity as Congresswoman Jasmine Crockett made her way down the marble hallway. She held her legal briefcase firmly, her expression unreadable but focused. Inside Courtroom 24, every seat was taken. Legal scholars, political reporters, and camera crews waited for a showdown that many sensed would be far from ordinary. Jasmine was there to defend the Voting Rights Enhancement Act, a law she had helped draft. But what she did not know was that Judge Neomi Rao, a sharp-tongued conservative jurist with a national reputation, had something else in mind: public humiliation. Rao, appointed by President Trump, was known for dismantling arguments with surgical precision. She had a reputation for using the courtroom like a lecture hall, and she was feared for her calculated aggressiveness, especially toward attorneys she disagreed with. But Jasmine Crockett was not just any attorney. She was a former public defender, a civil rights warrior, and a woman who had made a career of winning battles no one else dared to fight. As Judge Rao took the bench, the air tightened. Her robe flowed as she sat down, casting a long shadow over the courtroom. She addressed the room with crisp authority, announcing the hearing of Texas versus Federal Election Commission, a constitutional showdown about whether federal law could override state restrictions on voting. Jasmine sat at the defense table, her papers in perfect order, calm but prepared for war. The judge began with the plaintiff's counsel, interjecting frequently with pointed questions that echoed conservative talking points. Then came Jasmine's turn. And that is when Rao's tone shifted sharply. "Congresswoman Crockett," she began, dragging out the title in a way that landed like an insult. "Are you confusing your political passions with legal reasoning?" The room fell silent. It was not just aggressive, it was personal. A sitting congresswoman was being openly mocked by a federal judge on live television. Jasmine did not flinch. She adjusted her jacket, stood up slowly, and responded with a controlled tone that held the tension of a drawn bowstring. "Your Honor, I am here today as legal counsel, and I am fully prepared to walk through the constitutional analysis, point by point." But Judge Rao was not finished. Her next question sliced deeper, targeting Jasmine's background as a public defender, questioning whether she had the qualifications to debate federalism in a courtroom like this. Legal observers looked at each other. No one could believe what they were hearing. But Jasmine? She just smiled, and that is when everything started to change. That smile on Jasmine Crockett's face was not arrogance. It was calculation. What the courtroom, and Judge Rao, did not yet know was that Jasmine had anticipated every word of this attack. She had come prepared not just with legal arguments, but with something far more explosive, a strategy designed to expose the one weakness Judge Rao could never afford to let surface. And Rao, in her overconfidence, was walking right into it. Judge Rao leaned in from the bench, doubling down. "Miss Crockett, you are relying heavily on a modern interpretation of the 15th Amendment. Would you not agree that your personal involvement in drafting this legislation compromises your ability to argue its constitutionality?" The implication was bold, too bold. A federal judge was suggesting that a sitting member of Congress could not defend a law she had helped pass. The gallery buzzed with low whispers, law professors exchanging glances. This was not just judicial aggression, it was dangerously close to ethical overreach. But Jasmine Crockett, standing tall in her navy blue suit, did not blink. Instead, she calmly flipped through her binder, marked with colorful tabs and sticky notes. Her fingers landed on one specific section, and that same smile returned. She had just been given the green light to unleash what she had been waiting to use. "Your Honor," Jasmine began, her voice steady and unshaken, Before I address the court's question, I respectfully request that the court address a preliminary matter. One that may impact this court's jurisdiction over the case entirely. The room fell still. Judge Rao raised an eyebrow, skeptical but intrigued. A preliminary matter? Yes, Jasmine replied, taking a step forward. I move that this court recuse itself due to a clear and documented conflict of interest that was not disclosed during case assignment. Gasps spread like wildfire across the gallery. Courtroom staff froze. Reporters hunched over laptops, fingers flying. Rao's expression darkened. Excuse me, counselor? The judge demanded, now visibly tense. Jasmine opened her binder. According to financial disclosures filed with the Administrative Office of the U.S. Courts, your husband has received over $340,000 in consulting fees from organizations directly tied to the plaintiffs in this case: the Constitutional Defense Fund, the American Federalism Institute, and the 10th Amendment Foundation. These organizations are financially and legally invested in the outcome of this case. Dead silence. Furthermore, Jasmine continued, you authored a law review article just 6 months ago in which you referred to this very legislation as an unconstitutional power grab. She looked up directly into Rao's eyes. That article was published before this case even came before your court. The judge's face flushed, her confidence cracking like glass under pressure. She tried to interject, but Jasmine spoke over her, gently, but firmly. This is not conjecture, Your Honor. This is federal ethics law. You are required to recuse yourself under 28 U.S. Code Section 455. This court's impartiality has been reasonably questioned, and that alone mandates your disqualification. The gallery held its collective breath. The woman Judge Rao had tried to shame had just flipped the power dynamic completely, and the hearing had only just begun. Judge Neomi Rao sat frozen behind the bench. Her once dominant posture had turned rigid, her eyes narrowing not in control, but in calculation. What Jasmine Crockett had just done was more than bold, it was precise, devastating, and completely grounded in the law. The courtroom buzzed with restrained chaos. Legal reporters typed furiously, whispers filled the gallery, and even the court stenographer looked up briefly, stunned by the turn of events. Everyone knew they were witnessing history. Counselor, Judge Rao said, her voice suddenly tighter. These are serious allegations. Jasmine, calm and deliberate, responded immediately. With respect, Your Honor, I am not making allegations. I am presenting facts that raise mandatory ethical concerns under federal law. Jasmine lifted a new set of documents from her binder. Here are the financial records I referenced, verified through official disclosure filings. Additionally, I have printed excerpts from your law review article, in which you stated, and I quote, "The federal government has no constitutional authority to enforce this type of voting legislation upon the states." Every word landed with weight. Judge Rao tried to reassert control. Academic writings are protected, Counselor. They are not grounds for disqualification. Jasmine nodded, never raising her voice. I agree, Your Honor. But when those writings demonstrate prior judgment on the very legal matter before the court, especially when paired with financial connections to involved parties, recusal is not optional, it is required. Canon 3C of the Code of Conduct for United States Judges makes that unmistakably clear. Rao's lips pressed into a thin line. Her hands gripped the arms of her chair. But she knew the rule. The same rules she herself had written about in a previous opinion. And Jasmine was about to remind her. Your Honor, Jasmine said, her tone still even. In Martinez versus Department of Education you wrote, the appearance of bias is as damaging to judicial integrity as actual bias. When a reasonable observer might question a judge's impartiality, recusal is not just appropriate. It is required. That was your own ruling, just 8 months ago. The gallery erupted in whispers. Even conservative observers, who had arrived expecting a political spectacle, now sat in stunned silence. Judge Rao had been cornered with her own words, her own rules, her own legacy. Jasmine, still holding the binder, looked back at the bench. Respectfully, Your Honor, We must all be accountable to the ethical standards we ourselves have set. If we are not, then the foundation of impartial justice begins to crack. It was not just a legal strategy. It was a moral lesson, delivered in real time. Judge Rao finally spoke. The court will take this motion under advisement. We will recess for 15 minutes. But everyone knew what that meant. Rao was not going to find a legal out. There was none. The judge who entered the courtroom expecting to shame a congresswoman had instead been forced into retreat, her authority undone by flawless preparation and unshakable courage. When Judge Rao returned to the bench, the transformation in her demeanor was unmistakable. The sharp confidence was gone, replaced by a rigid formality. Her voice, once commanding and laced with challenge, now sounded mechanical as she read from the bench. After reviewing the authorities cited by counsel, this court grants the defendant's motion for recusal. This case will be reassigned to another judge on this circuit. And just like that, the confrontation that had begun as a judicial ambush ended in complete reversal. The courtroom, stunned only moments ago, now stirred with hushed chaos. Legal reporters rushed to send breaking alerts. Cameras outside the courthouse scrambled to prepare live coverage. Jasmine Crockett had not only survived a federal judge's public challenge, she had turned it into a legal masterclass. But she was not celebrating. She calmly collected her notes, zipped up her briefcase, and exited with the same steady grace she had entered with. This was not a moment for showboating. It was a moment of quiet power. Outside, the story exploded. Major news networks interrupted programming with urgent banners. Federal judge recuses herself after Congresswoman uncovers conflict of interest. Twitter lit up with legal commentary, praise, and political firestorms. The hashtag Crockett Destroys began trending within the hour. Legal Twitter, a tight community of attorneys and law professors, praised the precision of her motion. This is what happens when you come to court with facts, ethics, and a spine, one post read. Jasmine had not only won the moment, she had changed the entire trajectory of the case. With the hearing reassigned to Judge Patricia Millett, a respected Obama appointee known for her neutral temperament, the future of the Voting Rights Enhancement Act now stood a real chance. But beyond that, something bigger had shifted. Crockett's victory became symbolic, a warning shot to any judge who might consider wielding their gavel as a political weapon. Behind the scenes, the fallout for Judge Rao began almost immediately. Ethics watchdogs announced formal inquiries into her prior rulings. Legal publications began combing through her past cases, looking for similar conflicts. And on Capitol Hill, the impact of Jasmine's performance rippled through both parties. Progressives rallied behind her. Representative Alexandria Ocasio-Cortez tweeted, "This is what accountability looks like. Jasmine just reminded the federal bench that Congress is not to be bullied." Even Senator Elizabeth Warren issued a statement calling for stricter judicial disclosure laws. But not everyone was applauding. Conservative commentators accused Jasmine of staging a political ambush. "This was not law, it was theater," one legal pundit claimed. "She is trying to scare judges off the bench." But those criticisms rang hollow in light of the facts. Everything Jasmine cited had been public record. Everything had been legal. And through it all, Jasmine remained grounded. In private, her staff said she returned to her office, responded to constituents, and went back to work as if nothing extraordinary had happened. But anyone paying attention knew something extraordinary had happened. A powerful federal judge had tried to shame her, and left the courtroom shamed herself. By the next morning, Jasmine Crockett's confrontation with Judge Rao had become the focal point of national discussion, not just on cable news, but across college campuses, courtrooms, and Capitol Hill. What had taken place in that courtroom was more than a legal maneuver, it was a public reckoning. Law schools began circulating the transcript of her motion for recusal. Professors called it a case study in courtroom courage. And for many aspiring attorneys, especially women and people of color, Jasmine became something much bigger, a symbol of what was possible when you met power with preparation. Meanwhile, Judge Rao's troubles deepened. Investigative journalists uncovered financial connections between her husband's law firm and 3 more cases over the last 2 years that raised similar ethical red flags. The National Law Journal ran a headline that read, "Pattern of conflict? Judge Rao's ethical web grows thicker." And just as Jasmine had predicted, federal watchdog groups began filing official complaints. The judge who once had her name floated as a potential Supreme Court nominee was now under intense scrutiny. But Jasmine was not interested in personal takedowns. For her, the courtroom confrontation had never been about revenge or humiliation. It had been about accountability. Her legal training as a public defender taught her to treat the courtroom as sacred ground. She had spent years standing up for people who had no voice, clients who faced judges far more hostile than Rao. That experience had forged something inside her that no courtroom insult could rattle. Her background, which Rao had tried to use as a weakness, had become her greatest strength. In the days following the hearing, Jasmine's office reported a massive surge in emails, letters, and donations. Attorneys from across the country sent messages of solidarity. Law students asked to intern with her. Civil rights groups asked her to speak. But Jasmine deflected the attention. "This is not about me," she told her staff. "This is about making sure the law applies to everyone, even those in robes." The reassignment of the voting rights case proved just how much had shifted. Judge Millett, now presiding, reopened the record for new evidence. Legal scholars noted that her initial rulings indicated a more balanced approach, focused on precedent, not ideology. And with Jasmine still serving as counsel for the government, the defense of the Voting Rights Enhancement Act was now on stronger footing than ever before. Back in Washington, political momentum shifted as well. Progressive lawmakers introduced new legislation aimed at strengthening judicial transparency. The proposal, unofficially named the Crockett Rule, sought to require judges to publicly disclose any financial or organizational ties to parties in their courtrooms, before a case ever began. It was not just symbolic. It was legislative proof that what had happened in Courtroom 24 was reverberating far beyond those 4 walls. And through it all, Jasmine Crockett kept moving forward, not chasing the spotlight, but proving again and again that the best kind of power is the kind that comes from knowing the law, standing firm, and speaking only when it matters most. Months later, the ripple effects of that single courtroom confrontation were still unfolding. Judge Neomi Rao's recusal had triggered not just the reassignment of one high-profile case, it had sparked a nationwide reckoning over judicial ethics. Court administrators across the federal system began receiving inquiries from advocacy groups, lawmakers, and reporters demanding greater transparency. Judicial ethics seminars were updated to include Jasmine Crockett's motion as required reading. What began as a tense exchange between 2 brilliant legal minds had grown into a national dialogue about trust, accountability, and the limits of unchecked power in American courts. Inside law schools, a new generation of students studied Crockett's strategy the way chess players analyze championship matches. They marveled not only at the legal citations she used, but the timing of her moves, the discipline in her delivery, and her refusal to be baited into theatrics. She had not raised her voice. She had not played to the cameras. She had simply let the law speak, and it spoke louder than any insult ever could. For young black women entering the legal field, Crockett became more than an inspiration, she became a blueprint. The way she flipped the narrative, using a judge's own words and rulings against her, demonstrated how deep preparation could disarm even the most powerful opposition. It was not about ego. It was about principle. Meanwhile, in Congress, the push for judicial reform gained traction. Several members from both parties, reluctant though some were, acknowledged that Crockett's recusal motion had highlighted a real vulnerability in the system. Federal judges operated with immense discretion, but rarely faced external accountability. The Crockett Rule legislation began gaining co-sponsors. Even some moderates who had initially hesitated began to support the measure quietly, recognizing that trust in the judiciary had become a bipartisan concern. As for the voting rights case, the outcome was decisive. Under Judge Millett's oversight, the court upheld the Voting Rights Enhancement Act in its entirety. The ruling was grounded in precedent, clearly articulated, and free from the political undertones that had tainted the earlier hearing. Legal scholars praised the decision as a model of judicial restraint and fidelity to constitutional protections. And Jasmine Crockett's fingerprints were all over it. She had not just defended the law, she had protected the process. And though she remained modest in public, those who knew her best could see how much the moment had meant. For years, she had faced skepticism, judgment, and the subtle disrespect that followed women like her in positions of power. But now, the nation had seen what happened when she was given a microphone, a podium, and the full weight of the Constitution behind her. Judge Rao may have entered that courtroom expecting to teach a lesson. But in the end, it was Jasmine Crockett who delivered one, a lesson in poise, precision, and the quiet strength that comes from knowing you are right. Because in American democracy, the most powerful tool is not the gavel. It is the truth, delivered by someone brave enough to speak it, even when the odds, and the judge, are against her.